Welcome back. That was an incredible lunchtime speaker series. I don't know about you guys, but I feel like it was an organ donation. This morning, we tackled the hardest questions and the challenges to the final ratification of the ERA, and we debated what to do about them. Now we're going to discuss what the ERA will do, beginning with the interpretive framework that we should all be applying outside of the status quo of the 14th Amendment Equal Protection Clause. So I am honored to introduce our moderator for this important discussion, Professor Naomi Mezzi, the Agnes Williams Sesquicentennial Professor. Let us just vow to never say that word again, especially in the context of the ERA. Professor of Law at Georgetown Law School, where she's also co-founder of the Georgetown Gender and Justice Initiative. Thank you.
Thank you so much. Is this on?
Yep.
Okay. This panel is titled in the program, If Not Strict Scrutiny, Then What? I've been thinking about it in my own mind as what will the 28th Amendment mean? And it really takes off from where the first panel this morning ended, really thinking about what happens when the 28th Amendment is widely recognized, officially ratified, what then? And it's exciting to be able to think about that. And it's an opportunity to not only speculate or prognosticate about the future, but to help create that future and to create the kind of egalitarian legal future that we want to inhabit. I thought what I would just do by way, before I introduce the panelists, is say that I think the panelists themselves start from a couple of shared premises. And it might just be helpful to spell out what I think they are. One is that the Equal Protection Clause itself, the source of our constitutional equality jurisdiction, is increasingly limited in its ability to recognize, let alone remedy, the most problematic issues of inequality and injustice, and certainly in its ability to deal with the very complex systemic dynamics that produce and perpetuate inequality. That's shared premise number one. Shared premise number two is that the 28th Amendment is going to create something new. And I think something new itself and in the text of the Constitution, or what Professor Nurse calls the uber text. And that means it will mean something new. And the panelists are here to explore what that is. And so to the extent that it creates new meaning, is it going to be modeled on current equality doctrine? How will it move beyond equal protection? And what might a much more capacious substantive idea of equality even look like? Let me introduce, I'll start to my left and move down and introduce the panelists. Olatunde Johnson is the Ruth Bader Ginsburg Professor of Law at Columbia University at the law school. Professor Johnson is known for her scholarship in civil procedure, legislation, and anti-discrimination law. Victoria Francis Nurse, my colleague, is the Ralph Whitworth Professor of Law at Georgetown. She's also a commissioner on the U.S. Commission of Civil Rights, and her scholarship spans the public law curriculum from constitutional law to legislation, criminal law, and gender. Wilfred Codrington is the Dean's Research Scholar and Associate Professor of Law at Brooklyn Law School. He's a fellow at the Brennan Center for Justice at NYU School of Law. His work focuses on constitutional law, election law, and public policy and anti-discrimination law. Last but certainly not least, Catherine Franke is the James L. Dorr Professor of Law at Columbia University, Director of the Center for Gender and Sexuality Law, and Faculty Director of the ERA Project. Their scholarship focuses on law, sexuality, race, and religion, drawing from feminist, queer, and critical race theory. It's an enormous honor to actually sit up here with all of you, whose work has really been an inspiration for me. I think I'd like to start with Professor Codrington, and partly because it's clear that you've been really thinking about what a 28th Amendment looks like in the context of the Equal Protection Clause and what that might mean for both the amendment itself and the Equal Protection Clause going forward.
Well, thank you, Naomi, and thank you everyone at Georgetown and Columbia for putting on this great convening, and to my distinguished co-panelists. It is so wonderful to be here to be talking about this really important topic. So yeah, I've been thinking about the ERA, and as Naomi said, I think we are all in cahoots here where we don't think that the current anti-discrimination or legal equality paradigm is sufficient in the 21st century. I'll start out by talking a little about what that looks like. So when we think about legal equality under the Constitution, we're speaking mostly about the 14th Amendment. There's some Fifth Amendment stuff we think about reverse incorporation in that way. But really what we're trying to do in terms of equal protection is to figure out whether a law is targeting a particular class, whether there is a good reason to target that class, and in the law's actual means, is it sufficiently tied to the goals? And those goals have to be of a certain level of legitimacy, right? And so we think about this in terms of, traditionally in terms of 3 different tiers of scrutiny: rational, intermediate, and strict scrutiny. I think that is a little bit of a masquerade for what really goes on in equal protection jurisprudence. Some have said there's up to 6, some have said there's more or less, but typically we try to think about it in terms of 3 tiers of scrutiny. Now, the reason why we think about the ERA as potentially modeling something like this is 2 reasons. One is textually, there are similarities between the Equal Rights Amendment and the Equal Protection Clause. Not precisely, doesn't mirror it exactly, but they do use some linguistic construction that's very similar. And the second is just doctrinally where we've gone, right? We've started with the Equal Protection Clause, specifically applying to race, and then moving on to cover other categories. And not most recently, but more recently, sex, right? And so we have this jurisprudence of sex equality that has developed in the 60s into the 70s and continuing to develop now. And so that has very much mirrored what we've done under the what we're doing under the Equal Protection Clause mirrors what we've done in race, but there's been different standards applied. And so now thinking about the Equal Rights Amendment, the question is, do we want to continue that model? Do we want to continue working sort of in the shadow of the Equal Protection Clause? Or do we want to look for something else, something that is going to be more appropriate for the modern circumstances in which we might want to apply the ERA, more appropriate in the context in which the ERA was ratified? And just more appropriate for us as a more diverse and ecumenical and robust society. So the ERA, given that it is of a newer vintage, it's not clear to me that we should be thinking back to the 1800s to look for a doctrinal framework. I'll stop there and talk, let my other co-panelists speak, but I'm happy to talk more about this along the course of this conversation.
Wonderful. Thank you so much. I think I'll turn to you, Professor Johnson.
Oh, yeah. Happy to do that.
Polity.
We went to law school together.
So
So she struggles to call me Professor Johnson.
No, it just feels slightly awkward. Wondering if you might expand a little bit on that, right? So to what extent do we want to be tied to the equal protection paradigm at all? And what else we might bring in to create that something new? Like it clearly has to be new. So what might that look like? Do we have other models? Might state ERAs help? Are there legislative models that that you think might
Yeah.
help expand on that idea?
Yeah, I'm happy to speak to that. First of all, thank you for inviting me here. I love the morning sessions and the afternoon sessions, and I learned so much. And I look forward to learning more as we launch this panel. I wanted to start in a slightly different place just by saying that that Representative Presley alluded to some skepticism or lack of connection to this issue that she had at first. And I have to say it was the same for me. I thought it would be nice to have an ERA. I don't know if I'm going to spend any energy or time or come down to DC to talk about it. But I've had a great shift in my thinking about it. And I think part of that is because I'm lucky enough to sit down the hall from Ting Ting Chen and Catherine Franke, but also to have come to other ERA conferences with people like Victoria Norris and Julie Suk. And their work has really convinced me that it's partly about a question. I'm an equality law scholar, about expanding conceptions of equality. And I'll get back to the roots of my skepticism. They have to do with constitutionalism versus other bodies like legislators and administrative agencies that sometimes have a more capacious understanding of equality. But I became convinced that it was necessary in terms of just expanding notions of equality, but also I think more fundamentally about democracy. Like, what does it mean to have a constitution that doesn't have a sex equality provision? Earlier or last week, I sat with a French constitutional law scholar, and she was talking about the French constitutional amendment on abortion. It's limited in some sorts of ways, but it reflects all of these different points in their constitution where they recognize that women have some citizenship rights. And I think you have to think about how the sort of expressive value or non-value, I guess, or non-expression of what it means for us to not even be able to instantiate that concept very clearly in the American Constitution, and how it flows to all sorts of areas of governance and power. So I think it's really important in that sense. And there's more to say about that. I think a lot about democracy and polarization and rise of populism. And I think that the question of gender is actually deeply linked with all of those things. And perhaps we can talk about that at some point. But just in terms of the equality provision, I mean, the way I'd pick up on Professor Coddington's comments on this is also to talk about disparate impact. I think there was a lot of discussion around strict scrutiny and the limitations of the strict scrutiny framework. And I think part of it goes to that thing that we learn about how the Supreme Court has shaped the doctrine in equal protection so that it's so much about anti-classification values, not about anti-subordination, and that gets instantiated in various ways. I think one of the worst constitutional cases is the Feeney case challenging the veterans' preferences. It has the most antagonistic language on using the Equal Protection Clause. Luckily, there's other language. So some of you may remember from con law is a challenge to a veterans' preference on the basis that it discriminated against women, and the court drew on its equal protection race jurisprudence to say there's an intentional discrimination standard, but then said it in the most hostile way, which is that it has to be because of, not in spite of, its effect on women. So we adopted this veterans preference to harm women. It has to be the standard, rather than what happens usually in law is that we have adopted things not even thinking about women. They're totally invisible. And we've created a whole system of state structure and support that recognizes someone's service to the state that doesn't recognize, for instance, caregiving or other ways in which you participate in a democracy or in an economy or support it. And so that's a standard that's very hostile. It's not the only standard. I just want to be clear about that. We could return to it. The intent standards also expressed in cases like Arlington Heights, but it's, I think it really is one of the things, if we're going to have a 28th Amendment, that cannot be carried over. It's certainly not the Feeney articulation, but even not an intentional discrimination standard. I would love to see, so I am a scholar of statutory anti-discrimination law. All the major civil rights statutes in some form have a disparate impact standard. It's absolutely manageable as a standard. It doesn't, as Washington v. Davis suggests, mean that everything is going to be under scrutiny. There are ways of sort of cabining it. But I think that you could look at Does a particular action perpetuate gender-based stereotypes? Does it perpetuate past discrimination? That's a pretty limited view of disparate impact, but that's one way to do it. That's there's an important expression of that in the Fair Housing Act. There's also unjustified impacts. Like if you have a particular action that has an impact on the basis of gender to one group or the other, is there a justification for it? And that again is not the most expansive, but I think can be important. I would love to see an ongoing duty, affirmative duty, and ongoing requirement of affirmative self-assessment and correction as a kind of a way of thinking about that. Some constitutions have that. They don't just say that there is a right. It says that the state has an affirmative duty to provide that right and also to remove impediments to access to that right. And that creates an ongoing duty of self-assessment at the way in which important social goods are not being distributed in fair ways. So that's some of what I'd like to see. A lot more to say on. And the only thing I'll end with is that I think the one way, I'm not saying I differ from the rest of the panel on this because I don't know what everyone's going to say on this, but one of the things I do want to emphasize is that I think the enforcement clauses of all the amendments, the equality amendments, 13th, 14th, 15th, and certainly the 28th Amendment are the most important piece of it, because I do think that Congress has the power to define the equality right more broadly than the Supreme Court. A lot of what the Supreme Court says when it has a very narrow definition of an equality right is we can't do this. It's too stressful for us. It's not in our institutional competence. The French constitutional scholar said their courts were shy. Okay, so our courts are not shy, but they act very shy sometimes when they want to enforce an equality right, and they get really worried about so many different things. And so that's okay, because we are supposed to have a Congress and a legislative branch that can help define those equality rights. So that depends on the relationship between that congressional role and the substantive role. And I think that has to be sorted out a little bit in the ERA.
Terrific. Thank you. Professor Nurse, I want to, partly because you have spent your career thinking about the constitution in a very holistic way, and you think so much about interpretation, constitutional and statutory. I wondered if you might say something about how you think the 20th Amendment will be interpreted and where it fits constitutionally.
Well, thanks for that. And I really appreciate Professor Codrington and Professor Johnson, otherwise known as Naomi's bestie, for being here. That was a really wonderful introduction. One of the things that law schools do is they're very focused on courts, but they're also focused on Mandarin cases that might actually be a bad sample of what actually goes on. So I've started a project where I've read everything in the court has issued since 2019, and it's on a website called the Supreme Court Interpretation Lab. And that brings me to some somewhat jarring conclusions, but you should know about them. I think the days of scrutiny are over. The court hasn't gotten there, but it will. Many of the justices don't like the concept. Now, maybe the First Amendment will keep it in there somehow, and I don't think they're going to overrule them en masse in any way. But that's not the language that they prefer. They speak in a different language that you did not learn in law school, and that even people here don't teach, even at Georgetown. So the language is more of history and tradition, as you saw in Dobbs, and common law. But that is why I've written several pieces about how women are the Achilles heel of originalism, because our existence was not factored into the common law. The common law actually dissolved women into their fathers or their husbands. And so it's a real serious problem. And I said that before Dobbs, and then we saw the common law in Dobbs. So this method has been percolating up for a number of years, even though we might not study it. You'd have to look at all these cases to see how much they're changing. So I never have thought that the equal protection, I look at a different set of cases in equal protection, because I've focused on, as I said at the outset, something that was very personal to me, and which I'm not objective at all, which is the decision in the United States versus Morrison. And that the court struck down a civil gender violence remedy by calling it about a crime. Odd, but they couldn't figure that out. And they also did it based on equal protection. So I've never been very sanguine about the court actually doing what Robin West would call equal protection. And this would apply across the board, not only with respect to women, but with respect to minorities and a whole bunch of other situations. So I've always been skeptical because I trace a different line of precedent involving violence. So I'm writing a book about this. You'll have to wait till I go on my sabbatical, but it traces the violence cases straight through to Dobbs. You can't look in equal protection for them. Some of them come up in evidence law. Some of them come up in procedural due process, but there is a through line of hostility toward gender equality in those cases. And you don't really see that. So those are my two interventions, which is to say, I don't know if we should focus only on the Equal Rights Amendment to talk about gender equality, because there are these other cases too. The court is focused on moving beyond scrutiny. So that's a good thing in some ways, because the old law wasn't particularly good. And I actually think there might be a silver lining. So there was a bit of reference to this by Professor Suk and Professor Posen earlier today, which is that they are very much focused on, if you're an originalist, the date of ratification. So they believe the reason that they look to the text is because that is a high moment of sovereignty. They have a whole theory about high sovereignty and low sovereignty. They think what we do on a legislative basis every day is low sovereignty and subject to rent seeking and a whole bunch of, it's basically corruption, they think. But the high moment of sovereignty is sacrosanct. And so my slight hope is that if it is passed in the 20th and the 21st centuries, as was mentioned earlier, that it will be viewed through the 21st and the 20th centuries lens. We got some help on a case called Bostock for sex equals gender more broadly. And so I do have some hope that even if they're not going to go back to scrutiny, it's that they actually will be forced by their own theory to look at this in a more modern lens. Now, obviously, I don't expect, they could be hostile. I know y'all believe they're going to do something bad to it, but let them. Why? The Constitution is more than courts. This is the hydraulic power of self-governance working. After Lochner, ours laws became a national issue because of Teddy Roosevelt. We saw this with Dred Scott. This happens at various key moments in our history, and Dobbs has set this up for us to have a democratic full majority movement for bringing sex equality into the Constitution where it has never. Over to you all.
Thank you. Professor Franke, going back to what Professor Johnson called sort of moving from anti-classification to anti-subordination, and hoping you might talk about to what extent that means really untethering the 28th Amendment from equal protection altogether, and maybe talking a little bit about what it means, what Congresswoman Presley called articulating the dream. What should this be, and what could this be?
Totally. So I think we need to dream a lot bigger or more bigly about the ERA, and I would say that's true with the issues that we were talking about this morning, but this afternoon as well. It is widely argued by many of the advocates and elected officials and others that the ERA would usher in a period of strict scrutiny for sex discrimination cases. I just think that's absolutely the wrong thing to ask for. Not only is it not good enough, it's the wrong thing. So why is it the wrong thing? And one of my wonderful co-panelists here said this: the era of tears is over. Not true. The court is more than happy to use strict scrutiny to knock down affirmative measures that government takes to dismantle sex-based discrimination or race-based discrimination. Look at the affirmative action cases most recently. In the religious liberty and free speech areas, the court is more than happy to mobilize strict scrutiny to protect evangelical Christian dissenters who have either faith-based or speech-based claims that they make. So strict scrutiny and tears go to work for the right over and over and over again, and more so every day in order to dismantle the rights that we occasionally are able to get our governments or other institutions to embrace. So I just think let's let go of strict scrutiny. It's not helpful. But more importantly, why would we burden a new constitutional amendment, a new freestanding constitutional amendment with the limits of a 19th century amendment? And Julie Suk has argued this over and over and is not nodding, and I want to give her credit for this way of thinking the problem. That what the ERA or the 28th Amendment could do is usher in a modern 21st century vision of equality that is not limited to the crummy version that we have under the Equal Protection Clause. Look at what a terrific job Equal Protection has done in dismantling race discrimination, and why would we say we want that too? Because it's been inadequate in race claims. Why wouldn't it be inadequate here? So if you look at all of the amendments to the Constitution, they have always added something new. They don't merely restate or improve upon existing amendments. If all we wanted to do, if all we were asking for was strict scrutiny, then let's amend the 14th Amendment, right? Let's amend the 14th Amendment and make it a little bit better or worse, as my position is on strict scrutiny, than it is right now. But if we're going to do something completely new with a freestanding amendment, let's think big. And the right has done that. And again, in the religious liberty and free speech cases, the right has forced the Supreme Court to discover a new source for equality rights in the First Amendment that is so much better than what we get under the Equal Protection Clause. They think big, they think creatively, they argue it at a point when you think, well, that's a laughable argument. That's a laughable argument. That's a laughable argument. Ooh, wait. The Supreme Court just embraced that argument. We have to do that too. Think big, keep pushing it, even when they say, oh, that won't happen. And in that sense, we just have to take a page out of the playbook of the right. So what might that be? What might those freestanding conceptions of equality that could be embraced in a 28th Amendment that bear no relationship necessarily to the Equal Protection Clause? Why would it in a freestanding amendment? Well, I'm going to just say Alati, not professor. That's okay. Alati references disparate impact. Absolutely. I mean, that is a modern reconceptualization of what equality means, that talks about outcomes, not inputs, right? What does this law actually do? What does this policy actually do? Even if we can't catch you thinking bad thoughts about sex when you implemented that law. And in that sense, the reference to gendered impact assessments that Alati referenced, I think, is really important. And it's something that, spoiler alert, we're going to be issuing quite soon in a report that Naomi Young from our ERA project has been working tirelessly on, a model policy agenda for executives in states with ERAs. You got one? Use it. And the first thing you should do is assess, before implementing policies and enacting new laws, what kind of gendered impacts will they have? And then you're on notice that what you're doing is discriminatory if you don't ameliorate those impacts. So that, I think, is incredibly important. And then taking a much more substantive rather than formal equality approach to equality. To what degree can we enact laws that dismantle structural discrimination? Don't just rule out bad thinking, sexist thinking, or sexist actors or animus, but how do we implement measures that actually do the work of dismantling discrimination? And again, strict scrutiny is not good enough. The Biden administration tried to implement the COVID relief package in a way that would target the communities that were hit most negatively by the shutdown of society around COVID. And that was restaurants owned by women and people of color. So they fast-tracked checks just for the first 2 weeks to women and people of color owned restaurants. And of course, some white dude who owned a pizza parlor and bar sued and said it's race and sex discrimination against me for those people to get checks 2 weeks early. And of course, the federal courts agreed. Ooh, strict scrutiny. This is race discrimination. Intermediate scrutiny. This is sex discrimination. But what if we had a substantive form of equality that looked at how to dismantle forms of inequality that are manifest in society? And there are ample examples in international law whether it's CEDAW or a number of other examples in international law around substantive equality protections, but also in constitutional regimes in other countries around the world. We don't have to make this stuff up. We have the oldest constitution in a modern democracy and the hardest to amend, and the only of our peers that doesn't include sex equality explicitly. So let's look to those other more modern constitutions. Okay, thanks.
Wonderful. Thank you all for those initial comments. And I'd like to, and thank you, Catherine. We're just gonna move to first names because I can't make it work. For thinking bigly and creatively. And so one of the things that I would love to hear anyone on the panel respond to is, if we think in the biggest possible way, in the most substantive or visionary way about the 28th Amendment, and we really are asking the rest of us to move away from equal protection, tiers of scrutiny, what does that mean to have then bifurcated ways of thinking about sex and race? Because if the if the Equal Rights Amendment gives us substantive equality with respect to sex, and race is stuck in the anemic, 14th Amendment tiers of scrutiny, what does that mean? And to what extent is it disserving, in particular, women of color, Black women who've been part of this movement from the very beginning, and as we saw at lunch, are leading the charge now? What does that mean for really more compound, complex questions of discrimination? And can they work together? Can those two conceptions of equality work together? And I'm happy for.
I mean, I can jump in on part of that, and because I am interested in its implications in an intersectional basis. I guess instead of answering that directly, I'll just say the note of kind of caution that I have, and I know that others share it. I just want to articulate it. I mean, so yesterday I was at a conference. It was a post SFFA conference, after the Harvard case. And there's a lot of talk in the race area about reclaiming the 14th Amendment. It's not like there's this idea of like, oh, that amendment that the strict scrutiny anti-classification amendment. I don't think that that's what people fought a civil war for, or maybe I don't know what they fought the Civil War for, but that's not what they wrote those amendments for. Let's
Or does Nikki
say.
Haley apparently?
Yeah. That's not what they wrote those amendments for. There's a lot of, I recently had a talk with Eric Foner, who's written about the second founding, and we know that radical abolitionists had an equal citizenship idea, and they weren't primarily concerned about color blindness. I mean, that wasn't really what it was about, to have a 13th and eventually 14th and 15th Amendment. And so I think so my hope, okay, just to turn it into more of a yes and not like, what good does that do us? Because is just to express something that must happen so that doesn't happen to the, right? So, which is more constructive. So I think one is that courts can't be the only location of interpretation. I think what happened, the strict scrutiny, all of that framework is created by courts. It's not there written out in the amendment that is how you should interpret the 14th Amendment. I think another interpretive thing goes to this sort of holistic interpretation. I mean, just a piece that I wrote with Jessica Bowman-Posen, we really took that idea on and saying there's an equal citizenship principle in the 14th Amendment that's not well written, but we get it from the 15th and the 19th Amendment too, right? That had to do with DC statehood in that context. So maybe the 28th Amendment can help us think about the 14th Amendment differently, right? Because we don't tear up the old pieces of our Constitution because it's so hard to amend. So we need to infuse them with new realities, but through subsequent amendments. Like there's a whole idea of that as an interpretive method. I think that would be super, super helpful. And then the last thing I would say is that the thing that gives me most hope for having intersectional analyses are actually the ratification debates that took place most recently, like the Virginia one, where they really do center these visions. And perhaps even if we are to stick to a methodology that depends on the super sovereignty moment or whatever you called it, maybe we can draw on that. That might be a lesson for it for constitutional interpretation in a way that can help Black women or other groups that are facing intersectional identities, but also maybe it becomes a basis for the state level legislative or federal level legislative and executive action at minimum. So that's just one idea. It doesn't fully answer your question.
Does anyone else want to?
Well, no, I think at some point I want to talk about what Congress could do, because I think that Alachi is correct. The big thing here is that Congress can imagine equality in totally new ways. That was why I started out this morning about my deep sadness at United States versus Morrison, because we were trying to think of equality in a different way, and the court could not get their mind around that. But with the new and renewed focus on Congress's enforcement power, it must be something new. It has to be something new that didn't exist before, as has been mentioned. So they're going to have to grapple with that. And I think they're going to take some lessons from other places. And we have learned about intersectionality. We have learned that a lot of what Title VII and Title IX did protected white women. And the reason you can't move beyond those in Congress is because of the Commerce Clause. The truth is that women's rights depend on commerce and commerce alone, because Congress has not been able to enforce the Equal Protection Clause particularly well in this court. And so that's not surprising. That means that all the intimate stuff, all the things we care about, gender identity, intimate bodily autonomy decisions, who we marry, all of those things have left out. And so that's why I think this is a Dark Brandon BFD moment, which is to say, I said that earlier, you weren't here. I think it really is a big moment because we have to think bigly. Thank you, Catherine. And
Not my term.
yeah, well, okay. We're all borrowing. It's all about a big borrowing, but I think that's why it's so exciting. It allows more creativity in law school classrooms, in legislatures. Look at the brilliant women who were here talking about their vision today. That was very inspiring to me. And I think those are the kinds of conversations that could move beyond our old divisions. You know, when I go to ERA conferences, which I'm now going to call the 28th Amendment conferences, I see people who used to be, you know, fighting with each other for a small bit of pie. And now we all know that we have to fight for this. This is a democracy movement, in my view, because this is, I don't believe in the theory of originalism. I think it's actually kind of dangerous because of its downgrading of normal sovereignty. But I do believe that constitutional amendments are a constitutional moment where we do recognize things that everybody should believe in and leaves out the tiny minority that have been nitpicking this over and over and over again since 1972. But what horrible things the Equal Rights Amendment will do.
Do either one of you want to jump in, or should?
Sure, I'm happy to jump in and say a little bit more. I mean, one thing that should be out there, the Equal Rights Amendment is the only part of the Constitution that was written by women. And we should think about that as an important phenom itself. That should have some independent significance, as this court likes to speak about other parts of the Constitution. And all of these legal frameworks and all of these legal tests have been developed by courts that have just been populated by men, right? And so I think that that itself is important, and that just tells us that we should think about it differently. But I have three other sort of points that just kind of fit into this conversation. One is that these legal frameworks are dynamic. These are not static frameworks. So it doesn't matter if we're amending the Constitution. The First Amendment standards have not remained in time. The Second Amendment, God forbid, Second Amendment standards have remained in time. But we see these things as developments that happen over time. And so I just want to push back at the point that the 14th Amendment has to be left in the 1800s while the Equal Rights Amendment can move forward to the 21st century. I don't think that that's true. Right. And so these are shifting and dynamic frameworks, and we should think about that. The second part of it is the reasons why they shift, right? And that's because of the political environments. Courts are responding to what's going on in the political environment. And so, you know, in the Equal Rights Amendments context, the Frontiero case is the perfect example of that, right? There's an open debate among 7 members of the court about what standards of scrutiny actually apply to the equal rights or the 14th Amendment Equal Protection Clause as it's protecting sex, and sort of thinking about that in light of the fact that the ERA was about to be ratified, so they thought, right? And so what are the implications of that? But that's, I mean, even more broadly, right? Like the political environment matters. The 15th Amendment wasn't enforced for 80 years. I'm an election law scholar, so I have to bring in some election law stuff, right? But when you look at Giles v. Harris, you know, the fact that the 15th Amendment was not being enforced in the context, in a very explicit context where the 15th Amendment should have applied, was because we were in that area of Jim Crow, right? Nobody cared about race. And so race in elections did not matter. This is all contextual. The political environment matters. And so in the context of the ERA, we should be thinking about what's going on, what drove these ratifications, right? This happened in the post-Trump time. This happened in the Me Too and the Time's Up movement. This happened when we had the women's marches going on. This happened in a large discussion about abortion and LGBT rights, right? So when the amendment is actually being ratified in that context, we should expect courts, we should hold courts' feet to the fire to actually take those sources and that sort of information in their interpretations. But the last point may contradict a little bit of what I'm saying. It's because really, I'm not a courts person either. I like in some regards, I probably shouldn't be the person up here because I don't put my faith in courts. And I think that it is more about the people and it is more about the other aspects of the government, but the courts will push back. Right. So the courts have never been really leading on any of these civil rights issues. Even when we think about the Warren Court, yes, they did things relative to the previous courts. It looked a lot better, a lot more forward thinking, but it was also working in line with the other branches of government. And that's why we got the work that we got in that period. And so we can expect the court to not be the most enlightened or visionary branch to be enforcing these provisions and to push back. And just to think about this, put this in context. We just had again, back to election law, sorry, I have to do it, the Trump versus Anderson case, and we're talking about the 14th Amendment, Section 3. And somehow they put into the standard a congruence and proportionality. Excuse me? Is this what the framers were really thinking about when they were trying to make sure that insurrectionists were not going to be leading our country? Were they thinking about congruence and proportionality? No, those are that's just to say that this is all in light of the political context. And right now we have, I think that there's a lot of sort of tension and sort of like between the revanchist sort of segments of our society and the obvious diversifying, more sort of equality-oriented, future-thinking segments of our society, and that tension is going to play out in the courts. And so I think that, one, we just don't need to be placing so much of our hope in the courts itself, but then when we do, to the extent that we do, know that what they're doing is not just a static thing, and it is responsive in some way or another.
Nice. I want to just sort of disclaim that I was advocating in any way for a 19th century vision of the Equal Protection Clause. I was sort of riffing off of Catherine's point, so I would love for you to respond in some way.
Well, I think the feminist movement owes an incredible debt to the movements for racial justice in this country as a constitutional matter and as a political matter. We
And
kind
vice
of
versa, apparently.
What's that?
And vice versa. Eric Boner would tell us that the suffragettes were big, were the abolitionists.
Yeah. But the constitutional paradigm of equality developed in the initial stages as one of racial equality, and then we said, "Oh yeah, us too." And there are many or some respected scholars who feel that the limits of the Equal Protection Clause in terms of protecting an equality value or principle were undermined by the addition of women's rights to the court's interpretation of the Equal Protection Clause. We can debate whether that's true or not, but certainly respectable people hold that view. So I think we owe a debt to racial justice movements. And so with a 28th Amendment that has a more robust, independent, freestanding conception of equality, it could level up intersectional claims and do the work that Wilfred was talking about of modernizing the Equal Protection Clause as well. And I think we have a kind of normative calling to do that, given the history of how sex-based equality has evolved really as a epiphenomenon in many ways, or a version of race-based equality. And we're in this together. And so if we can move sex equality, let's do it in a way that levels up race-based equality too.
Love that. Thank you all.
Here, here.
So you all have talked about sort of how to think about this as an equality clause. But one of the things about thinking about the actual ratification, not only just thinking bigly or creatively, but like really concretely ahead, like what comes next, right? Like what needs to be lined up for ratification? What comes next? I'm thinking of enforcement legislation. What is that? So what kinds of cases should we be thinking about that will invite the more substantive and fulsome ideas of equality? And what kind of enforcement legislation do we need in order to do that as well? Because I think we need to be thinking ahead to both Congress and the courts, and what the movement does to begin putting in place some of the ideas that you all have articulated. And I'm
going to riff off of Aladi's comments, which is to say that and Julie Suk knows this, lots of other countries have more robust systems in dealing with gender stuff. You know, there's a book that someone's going to remember the name of involving, you know, how gender bias exists in all data in the world.
Invisible women. isn't it
Yeah.
called?
And it begins
Yeah.
with a discussion of how they get rid of snow in the
Love that.
in the Nordic countries, and it turns out that there's a gendered impact, right? And once they figured out the gendered impact, though, on strollers and all that kind of stuff, they actually make it better for everybody. It's a little bit like the cuts in the road for the disabled that turned out to be good for strollers. So that's why I see it as a leveling up movement, because it gives us hope for something we want to attain. So what I heard from you, and you can correct me, is that we need enforcement legislation that is a constant reassessment and auditing of all our laws. I've just published an article with 5 years of students about how the common law in tort is deeply discriminatory. So I want the states to do audits of their common law, because we need a constant reimagining and enforcement mechanism that is not just about courts. We have relied upon courts too much, but the people who experience these in the world, like, you know, Representative Bush and Representative Presley, bring new meaning. The kinds of things they were talking about, you know, they hear from, you know, people in their districts about what it is to live and how those things are intersectional. That's the kind of thing that Congress needs to get its mind around, and in whatever form it might be. It doesn't look like our traditional kinds of enforcement legislation, but it is the kind of thing that if you build an institution, it will continue to function in Washington, and it needs to be a robust one that is paid for in some way to continue that assessment.
Yeah. I see that Professor Suk wanted to get in on one of these points. Yeah. It's up to
Please,
you.
hop in.
Point that I think policy was thinking earlier about having a positive conception of equality.
And Catherine was saying we could have a substantive equality vision in this modern amendment, and Victoria was talking about institutions. And I think one aspect, and I'm guilty of this, I think in the first article I wrote about the ERA, I think I might have just like I might have just like cut at before Section 3. I just talked about Section 1 and Section 2, but Section 3, this amendment shall take effect 2 years after the date of ratification. It seems like, who cares? And if you actually look at the legislative history in the early 1970s, Martha Griffiths and Patsy Mink, who was the first Asian American woman in Congress, They actually talked about how you needed a delay because of the big change that was going to come, and it gave room for Congress and state legislatures and other institutions to prepare by doing gender impact assessments and making lists of all the laws that they would have to repeal and all the things they would have to do now that there was an equality duty on all governmental institutions. So I think we need to sort of read that history into the 2 years after the date of ratification, because the only other place in the Constitution you see that, and this is not some place we like to look because it's considered a constitutional mistake, but I think it is productive to look at the Prohibition Amendment because it just prohibited the manufacture and sale of alcohol, yes, but the effective date 1 year after ratification was important. Because Congress needed to, and state legislatures needed to pass legislation. And whatever you think of prohibition as a policy goal, the framework is a totally different framework, but I think it's echoed here in the ERA, which is that it's not just about a self-executing court-enforced equality model, but it puts duties on institutions to get ready for big change and to constantly monitor big change, which is what the amendment is about. And so I thought that maybe like trying to incorporate Section 3 and its history into our discussions of what's coming in the future would be helpful.
That is really helpful also because it has us think about Section 2 differently, which is is a big concern, right? That, what Wilfred referred to earlier, the idea that the court says, okay, so the 13th, 14th, and 15th Amendment all have an enforcement power. They say Congress should enforce this law, and they imagine Congress as the primary enforcer, not litigation even as the primary enforcement mechanism. But then you have, and I think that that's a wonderful thing that happens. We have a second Reconstruction that we shouldn't write out of our substantive equality notion, which are all these civil rights laws that really expand our notion of equality. But then we see all these laws are constantly in tension with the court's articulation of equality. So every disparate impact provision is now being challenged as violating the Equal Protection Clause. We had Shelby County where the court was not deferential at all to Congress, or not sufficiently deferential to Congress, and also seemed to not really cite the purpose of the 13th, the post-war amendments. And so I think that that example that you have also stands for a different conception of what congressional role is, which is that it's an affirmative role that we imagine, and it's not necessarily tethered. It creates an affirmative equality assessment duty, and it's not tethered to this narrow notion of whatever the court says is the equality notion. That is what Congress can do. So I think that's really important. You asked us, what would we do? And I guess we could all sit here and give our sort of litany of, amazing things we want Congress to do, but it seems like the category that some of us have fixated on, or that Congress, states, and administrative agencies, which have the power to do this probably anyway, could pass a whole bunch of affirmative legislation. They could do these kinds of ongoing equality assessments. I mean, I would love to see something that really tackles parenting and caregiving leave as a kind of broad both reproductive justice and care agenda. I think Congress has the power to do this right now anyway, and I think it actually has the power to have it applied to states anyway. But I think this buttresses the power to be sure. So that's one thing that I would add to the list. And I guess maybe one other thing is that is more defensive. A lot of states have been very interested in making changes to political power arrangements and economic power arrangements through things like laws that require a certain number of women at least to sit on corporate boards, or God forbid, we have something that like France and a whole bunch of other countries have on parity in legislatures. You couldn't do that in the American context. And in fact, you initially couldn't even do it in France. Apparently, the court struck it down and they had to amend their constitution to do it. But if we have a broader vision of equality in the 28th Amendment, maybe those things would be defensible, because we already have recent cases saying that it's not, and you can't do that, it's unconstitutional. So you would have a rewriting of that kind of history. I think that could be important.
Well, I also think right now, like starting today, every time a member of Congress talks about the ERA, whether it's the archivist bill or the deadline bill or any of these bills, they should be talking about the standard of what will the ERA do. So we're creating legislative history that we can put to work later, not just how do we lift the impediments, but what is this measure? What kind of substantive equality, disparate impact, whatever. And, we've got talking points for you guys who work for those people that we can give you today. So that legislative history has to be the way people are talking about it. And I think governors and state legislators can be doing it too. They also voted to ratify. Why did we ratify? Because we thought it would do something different than what the Equal Protection Clause is doing right now. The other thing, if we want to think big about what the administration can be doing besides mandating the archivist to publish, like very bigly, the president could say, I regard the 28th Amendment to the ERA to be the 28th Amendment, and I'm going to start implementing policies that are new, that are affirmative policies designed to dismantle sex-based inequality that are structural in nature. And I think we should pick off a few things that the court's been really bad about. So these affirmative measures that are, whether we call it affirmative action or other measures that take sex into account in order to address structural inequalities, substantive-based equalities, and then I think reproductive rights stuff, definitely. This court insists that discrimination on the basis of pregnancy is not sex discrimination, but the Nevada and Pennsylvania courts have held otherwise recently under state ERAs. Let's have the president say, yes, it is under the 28th Amendment, and start having people act as if these are the political facts, the culture change that we were talking about this morning. And then one last big idea, it's in your little packet that I'm promoting, is jurisdiction stripping legislation. Congress can pass a resolution stripping the federal courts of jurisdiction over disputes related to the final ratification of new amendments to the Constitution. So disputes about Article 5 are essentially political questions. The courts should not have jurisdiction over them. So while Congress is working its way through these various bills, we would cut off the federal courts as an avenue for answering the question and let it work its way through politically. And it's absolutely something Congress can do. And I've got 3 different versions of the legislative language, if you'd like, because we've got several different versions of the timeline legislation. That I think is an affirmative measure that we could do right now to kind of hold this period for elaboration of a new version of equality as a political and political matter through Congress and the administration to set up the right cases once they start getting challenged.
Love it. Okay. I have one more question, and then I want to turn things over to questions from the audience. We've talked some about race, and we've talked about sort of what needs to be in place. 2 years goes quickly, and what needs to be in place, and what do we want to sort of lay the groundwork for in terms of realizing a more robust version of equality. One thing we haven't really talked about is a 21st century version of sex. And in fact, one that is now statutorily implemented is sex means gender identity and sexual orientation. And so a 28th Amendment is going to queer the Constitution. And I want to know what it means. What does it look like to queer the Constitution? Because sex now means that, and that we're bringing that into the Constitution in a way that I haven't heard people talking about very much. And I'd love to know your thoughts if you have them.
We have an FAQ on this on our website. Shameless
Here's the
plug.
QR code.
Yeah. And we won Bostock, but what a crummy win. I mean, it was just a terrible decision. The reasoning was just awful. So I think, yes, the outcome was right, but
Hannah and Bob.
what's that?
Hannah and Bob.
Yeah, right, Hannah and Bob. So the outcome was right, but I think we need a richer account of why, as a constitutional matter, sex equality protections necessarily include sexual orientation and gender identity discrimination and freedom. And I think in that sense, we also might want to marry ideas of equality and freedom together in a new 28th Amendment that would, I think, ineluctably also include reproductive justice and things like that. Things that the Supreme Court just couldn't get anywhere near in Bostock. So that's a start, but I just don't want to say, let's read Bostock into a 28th Amendment because it's such a terrible case.
Can I just mention one quick thing, which is I think I argued this in some places, you know, it's helpful to have text, not only because, you know, we're such an outlier in the world, but also to resist the explosion of other rights that you might not like gun rights. We're having a case up there now, Rahimi. But also with respect to gender identity and gender minorities, because there are a lot of religion clause cases up there, and it's all fueled by a certain kind of religious anti-equality norms about sexual orientation and transgender. And if you have another textual right, you have a much stronger right to push back on the 1798 version or the 1868 version. So I don't think you should, stopping backsliding is a really why this is urgent at this point.
I'm going to co-sign a lot of what my co-panelists said. So one, Catherine said that Bostock wasn't great. I'm going to say a lot of the court's LGBT jurisprudence is not great. Honestly, I mean, even if it was forward thinking or moved us to a better place, like Obergefell, I really hate reading that opinion. You know, I love the rights, but how marriage became the end of the LGBT right movement itself, it really seems problematic to me. It just seems to me that we take these narrow views of these amendments in ways that just need to have a more holistic, a more robust reach. And so I'm going to co-sign that. I think what Julie was speaking about this 2-year period, I really think we should think more deeply about this, because that's critical. I think when we start talking about the invisible costs that we encounter, that women encounter, that people of color encounter, we really need to be thinking about that. And so part of this is decentering our notions of equality, so it's not such that the you know, a white straight man is the sort of ideal. That's the norm that we should be thinking about. We need to really think about the invisible costs on the others group. I mean, obviously, this is a hat tip to what Olati was saying. She mentioned intersectionality. Think about in the sort of Pauli Murray, the Kimberly Crenshaw model, right? We need to just kind of get out of this mindset where equality means how we treat white men, and as opposed to excavating how we are treating everybody else, and sort of thinking about that holistically, how that becomes a standard, and then work around that.
Yeah, I completely agree. I guess I'm too old to say I co-sign things, but that's what that's what I do on that. Yeah, and I think it maybe even new language. I mean, so I love that you said queering the Constitution, that it made me think about whether equality, I understand it's part of the words there, and it's an important notion. But we also talk about full participation. You know, we talk about freedom. We talk about what does Amartya Sen say? You know, kind of capabilities, thriving, full participation. My colleague Susan Sturm always uses. I mean, those things have to kind of go along with it, and that's part of the model. We're looking at all of us and saying, how are we designing a society to be, you know, inclusive along these dimensions?
I think if we were going to queer the Constitution, we would move away from identity and towards power. And rather than the sort of Caroline Products footnote 4 form of identity, for those of you who are lawyers or law students, and think more in a way that Loving versus Virginia, the court there invalidated the race-based miscegenation law in Virginia. It did so because not because the law classified between white people and black people, or white people and non-white people, but because the law perpetuated white supremacy. It bespoke white supremacy. And I think a 28th Amendment can also do the same kind of thing of thinking about patriarchy, not about women, and the ways in which heteropatriarchy or cis heteropatriarchy, we use a lot of terms that we jam together now. You can co-sign that.
I will co-sign that.
Well, I think would be a really productive way to think about rights and citizenship rather than identities. And identity is a very 20th century way to think about values, I guess. And power, I think, is a much better way, a more 21st century way of thinking about what this Constitution can deliver.
So I want to just ask our co-hosts here, we have about 7 or 8 minutes, 6 or 7 minutes.
Our speaker for the reception is here. Senator Hirona has
Yeah.
arrived, so I think we have like 2.
Okay,
Okay.
all right. You know, is there someone who has a pressing question from the audience? Please.
And we have a mic up here. Yeah.
Is this working?
Mhm.
I hope this counts as pressing. I just was sort of dying to ask it. And I want to pick up on the queering the Constitution part. I'm Julie Gonen with the National Center for Lesbian Rights, also a Georgetown law alum. We are seeing, obviously, everybody knows, a super vicious attack on trans people right now. It takes a number of forms. One is bans on medical care for trans youth that are based on, or that are being upheld by federal appellate courts based on a couple of things. One, they're not sex discrimination because they apply to both boys and girls. And, they're simply based on basic biological differences between the sexes. We're also seeing now these really pernicious state laws defining sex based on reproductive capacity alone. So I guess while these laws are aimed at trans people and literally defining them out of existence, they have really serious implications for sex discrimination law more broadly, because to the extent we've made any advances, it's by moving away from biological differences and reproductive capacity. So I guess I'm curious if anybody wants to comment on how the ERA might address those state laws that, again, they think they're just targeting trans people. Maybe they think they're doing more than that. They are, because of the bases on what they're based on.
Great question. I think we're all looking at you, Catherine.
Well, the better argument in Bostock, and I know you work on this, and it was argued to the court, but the court was like, what? Was around stereotyping, sex-based stereotyping about what does it mean to be a girl? What does it mean to be a boy? Is when you enforce a particular ideology, whether it's Ann Hopkins, who's not masculine enough to be a partner, or is too masculine to be a partner at Price Waterhouse, or these people who say this is what being a boy means to me, or this is what being a boy means for a girl means for me. This is all grounded in sex-based stereotyping. And that argument, I just think, is a lot more, it's much more capacious. It actually resonates a lot more with why we have a norm against sex discrimination, is not just that women should get what men have, but that none of us should be burdened with outdated and arcane notions of who men are and who women are. And that would, I think, easily extend to the cases of sexual orientation and gender identity discrimination, because they really are based in stereotypes about who men and women are. So it's unfortunate that the court in Bostock didn't embrace that theory. The EOC did.
And the lower court.
And
too.
the lower
Congress
courts
did in
did.
1991. I hate
Yeah.
that they didn't pay any attention to 1991.
But thank you
Yeah,
for raising it.
that's-
Yeah.
Yeah.
Could I
Great
just say
point.
that means that those are very important laws, because that's part of a bigger movement to reduce all people of a certain biology to a certain gender stereotype. So everybody should be for trans rights, for LBG, whatever. I can never do the list. Anyway, gender minorities. It is a democratic movement. It's not an identity movement, in my view.
And some people have used, and it sounds very large, but the word gender fascism, and it's like, it's linked to other ways in which we're constituting who can be part of our community. I mean, the ways in which those laws reflect the idea that there's no place for you to be is what's so chilling about them. Like that's what they're trying to do, almost excommunicate you from the society. And that is so corrosive in a democracy. That we have to look at them, I think, in that way. And I agree with everyone. Co-sign.
Co-sign.
Okay, we gotta go.
Will you all join me in co-signing? What has been a terrific.
I want to invite everybody to a reception that we're having over here. Senator Hirono has joined us and is going to make some remarks also about the ERA. And thank you all for coming and being with us today too, and for all of the incredibly hard work you're doing to create a more just world.